So you need to hire a lawyer, and you're thinking about the ways you can pay this lawyer. Okay, in today's video, I'm going to discuss the 4 most common ways to pay an attorney and provide you information you need to know before you actually engage a lawyer. My name is Mehdi Cherkaoui. I'm a civil litigation attorney in Houston, Texas. My channel provides general litigation information to the public. If you like this kind of content, I ask you to subscribe, hit the like button, hit the bell so you can be notified each time I post a video, and let's get to it. But before we get started, I am not your lawyer. This is not legal advice. This video is for informational and educational purposes only. If you have a situation that it requires legal advice, I suggest and recommend you seek an attorney in your local city or state. There are basically 4 ways when you hire a lawyer, there are 4 ways to pay them. There are really 3 ways, but there is a 4th way that is less popular, less common, and even sometimes frowned upon in certain jurisdictions. So let's start with the first one. The first way you can pay an attorney is by the hour. This is the most common way to pay a lawyer. You basically pay the attorney each time they do any work. The way it works is you will provide a retainer to the attorney. Let's say it's 10 hours of work, 20 hours of work. So if the attorney's hourly rate is $400 an hour, the attorney may ask you for 10 hours up front, which is $4,000, or they can ask you for 15 hours up front, which is $6,000. So that is the first amount of payment that you're going to pay to an attorney in order to start the process. So what the attorney would do with this money is that they will take that initial retainer and they have to deposit it by law in their trust account, also known as the IOLTA account. This is an account that is separate from their business account, which is the law firm's business account. This is a trust account where clients' money is being stored. At the first day of representation, the attorney has not done any work yet, so that retainer is now deposited in the trust account, and they have not earned any of it just yet. When the case started, let's say the attorney is defending you from a lawsuit that you received, you were sued, and the attorney is defending you. So when the work starts, the attorney is obligated against by law to document all the work that he or she is doing. So as soon as they start working on something, let's say they're drafting some kind of pleading, or they're writing an email, they get with you on the phone, or do they get with opposing counsel on the phone, they log in the time that they've spent, and they have to document that in a software or manually, or there's a lot of law management softwares that allow the attorney to make time entries detailing the work that they've done and the amount of time that they spent doing it. A lot of attorneys will round up to the nearest 10th of an hour, a 5th of an hour. In other words, the minimum that they'll be able to bill is for 10 minutes. So if they spend 5 or 6 or 7 minutes on a matter, then they're going to round it up to 10 minutes and bill for that. This is the most common way, again, to hire a lawyer. It's also very costly because in litigation, you can't really predict how much is it going to cost. A lot of cases, they settle fairly quickly. And there are cases that can last all the way to trial. And these attorneys' fees continue to pile up. What I would suggest is when you hire an attorney on an hourly basis, if this attorney, such as in our firm, we have a law practice management software that allows the client to log on to their account, and they can see in detail what the attorney has done and what they've billed and how many hours they've already worked. This gives you a chance to gauge where you are and how quickly you need to replenish this retainer. So again, the attorney is going to work based on the amount of hours that they have asked for in the beginning, corresponding to that retainer. And once that retainer is over, then you're going to be asked to replenish this retainer until that second retainer is exhausted again. You also want to have a contract. You want to make sure that this is all described in a contract between you and the attorney, and some contracts will explain what the attorney is going to charge versus what a paralegal is going to charge versus what an associate is going to charge as opposed to a senior counsel, etc. The second type of way you can pay an attorney, and in my opinion, the most beneficial to both sides, is a contingency agreement. So what is a contingency agreement? A contingency agreement is when an attorney takes a percentage of any and all money that you recover from the defendant. These are very common. These type of agreements are very common in a personal injury case. Let's say you suffered a damage or you suffered injuries as a result of a traffic accident. You go seek an attorney. The attorney takes on the case, and you hear this phrase, "You pay nothing until we recover." That is a typical contingency fee. They're usually about 1/3 of any type of recovery that the attorney gets for you prior to trial, and then it goes up perhaps to 40% if the case goes to trial. Why are these, in my opinion, the best type of way, these agreements are the best way to pay your attorney? Well, because they keep the attorney motivated and they keep the attorney interested. In other words, the more he gets for you, the more the attorney makes. You compare that to an hourly basis, for example, the attorney has no type of incentive or motivation to get you as much money as possible. You want an attorney that's negotiating on your behalf to be personally incentivized in the amount of money that he's going to get for you from the insurance company or from whichever company or individual that you have sued. It almost becomes like a business relationship. The lawsuit is the business. That's how I look at it. The lawsuit is the business. You own 2/3. The attorney owns 1/3. And once this business makes money, then that's how you guys split. So there is a partnership between you and your lawyer, and the end goal is to get as much money as possible for this business for you to split with your attorney. It's also very good for the client because there is no money to spend up front. When you get into a contingency agreement, you want to make sure that you get with a law firm, with an attorney that has the knowledge and the resources to be able to pay up front for these kind of cases until they get to settlement. Some cases could be very expensive. For example, in a personal injury case, it could require medical experts. These medical experts, a lot of them will have to be paid up front. Very few will agree to wait to be paid until the case is resolved. So the attorney or the law firm that you hired, you want to make sure they have the resources to pay for these medical providers and these experts, depositions, and all kind of legal fees before you actually get any kind of resolution. You want to make sure, and this is very important, in the state of Texas, a contingency agreement must be in writing. Again, you want to get a contract with your attorney that explains exactly what the contingency fee is, what are the attorney's fees, what are the costs of the litigation of the lawsuit that the attorney will have to pay up front. Keep in mind that if the attorney pays legal costs up front, such as deposition fee or expert report fees or filing fees, that the attorney will deduct these fees first before they take the contingency. To give you an example, let's say the attorney advanced $2,000 in legal costs and the case settled for $100,000. When the $100,000 comes into the trust account of the attorney, the $2,000 is being deducted first. And then the remaining $98,000 will be subject to the percentage split between you and your attorney. So try to get into a contingency fee agreement with an attorney, with a good attorney, anytime that you can. You must keep in mind that there are certain types of practice areas where the law completely forbids a contingency agreement. Two that come to mind: first, a criminal defense case. You cannot hire an attorney on a contingency agreement with a criminal defense case. You can't say, I'll take certain percentage. First of all, there's no money to get. He's just defending you from a charge. So there is no contingency agreement with a criminal defense attorney. There's also no contingency agreement, at least in the state of Texas, in divorce cases that involve child support, separation of assets, etc. You cannot give your attorney a percentage of child support or a percentage of spousal support. That is frowned upon. It is not allowed in the state of Texas. Now, if the attorney gets you a judgment against your husband or your wife, and you could not collect on this judgment, and you hire the attorney to collect on this judgment, then yes, in this situation, the attorney can take a percentage of the amount that they collect for you as a result of this judgment in a family case. But the actual divorce case that involves child support, spousal support, and separation of community property, the law does not allow any type of contingency fee. The third way you can pay your attorney is simply with a flat fee. So a flat fee is a sum of money that the attorney will charge, and it's due upfront, and it will take care. It's supposed to be a compensation for the attorney for work from A until Z, from the beginning of the case all the way till the end of the case. And it's all, of course, negotiable. You want to make sure you negotiate with your client, but you also want to keep the attorney, you want to negotiate with your attorney, and you want to keep the attorney motivated so that they can continue to work on your case. Flat fee cases are popular in certain types of areas of law, such as divorce cases, immigration cases, traffic ticket cases, and things of that sort. What I do suggest, if you decide to hire a lawyer and pay them a flat fee, is to ask if the lawyer can give you a payment plan. Let's say the flat fee is $10,000. You want to see if you can pay the attorney $2,000 up front and then perhaps pay $1,000 each month, especially if the case is going to take a long time. One of the things that I can tell you, maybe one of the drawbacks of a flat fee, is if you pay the entire fee to the attorney and the case lasts 6 months, a year, 2 years, you may notice that this attorney can become less motivated to represent you. Perhaps later on in the representation, he or she doesn't return phone calls, doesn't return emails. That may occur in the event that the attorney loses any type of motivation because they've already paid. So if I were a client, what I would do is enter into a payment plan with the attorney where you would pay them perhaps a 20-30% of the fee up front, and then you can pay them on a quarterly basis, on a monthly basis, depending on how long this case is likely to take. You also want to have a contract with the attorney that details exactly what the flat fee is for, and make sure that the contract states very specifically that the flat fee is compensation for the entire case. So in the case of a divorce and you want to pay, and you guys agreed, you and your attorney agreed on a flat fee, you want to make sure that it's a fee that covers from the day of filing until an order of divorce is issued. The last type of way you can pay your attorney is called a hybrid fee, which is not very popular. Certain jurisdictions even frown upon it. It doesn't mean that it's illegal, but you have to make sure that you document everything about this type of compensation in your attorney-client agreement. So here's how it works. Let's say you want to sue a company for a breach of contract. You ordered, let's say you want to sue a manufacturer, a vehicle, or an auto manufacturer. You ordered a vehicle, it turned out to be a lemon. They wouldn't agree to exchange it or give you a refund, so now you need to hire an attorney. Well, this kind of lawsuit can get expensive. The good news is for you and your attorney, you are suing an auto manufacturer, which means it's an established company, hopefully, that has assets, and once you get a judgment, you executing on the judgment is never going to be an issue. Okay, So in this case, an attorney may be interested in a contingency agreement, but then they're not sure how much is it going to cost and how much is going to cost the attorney in order to pursue this case all the way to trial, or at least all the way to settlement. So they may be looking at some expert fees, perhaps an engineer that can examine the car, and he needs to test it and provide the attorney with an expert report. That report is not cheap, it's expensive. So in this situation, the attorney and the client can agree to an upfront payment that is designed to go to litigation costs, such as expert reports, depositions, travel expenses, things of that sort. In exchange, the typical contingency percentage is lowered. So an example would be you and your attorney agree that you will give the attorney $5,000 to be deposited in a trust account, and that will go to litigation expenses, so that the attorney does not have to pay that up front. In exchange of this first $5,000 payment, the attorney agrees to lower the typical percentage, which is 1/3 of any kind of recovery. They agree to lower it to, let's say, 25% or 20%. In this situation, there is kind of a quid pro quo. There is a consideration for asking for the first $5,000. In exchange, you get a lowered percentage, and it can work for both sides. The client gets to keep more of their recovery because the percentage went down. The attorney does not get into, or does not incur, a lot of risk, because they don't have to pay the first $5,000 out of pocket, and it's covered by the client. That's it for today's video. I hope you enjoyed the content. If you like these kind of videos, I ask you to subscribe to my channel, hit the like button, and I'll see you guys on the next one. Take care.